Hello friends, I am Neeraj Kumar, Assistant Professor at National Law University, Dwarka. Today we are going to interact on module of Judicial Activism and Judicial Restraint, which is part and parcel of a paper on judicial process. Let us start with the outline of presentation. That is the way in which we are supposed to understand or the parameters which we are going to discuss with respect to the module. So firstly, we will try to look into the origin and the meaning of judicial activism and judicial restraint. Secondly, we will try to identify the various issues in judicial activism and judicial restraint, and then we will try to look into that what are the reasons because of which this judicial activism and judicial restraint issue arises, and then we will see the recent trend in the recent judicial trends with respect to these issues. So let us start with now understanding of judicial activism. So for proper understanding, let us try to appreciate the fact that generally most of the democratic societies operate on the basis of what we call as separation of power, the term popularized by Montesquieu in the modern context. So for the purposes of understanding the importance of this concept, let us imagine a situation that all the powers reside in an individual. So suppose a legislature is supposed to execute the law also and is supposed to decide if a dispute arises, then what can be the situation? So he will come up with a law where all the civil liberties are curtailed. Subsequently, he will execute it in a most draconian manner, and if any person wants to raise this issue through judicial process, he is the person who will deliberate upon this issue, and that will not be a very happy scenario, and that is why this separation of power concept is very important. Once we recognize the concept of separation of power, we recognize that there are different entities which are supposed to perform different functions. So in that context, the judiciary's role also comes into the picture, and judiciary is supposed to act as an arbitrator if a dispute arises. Now as an arbitrator, and more so in those legal systems where they have power under the constitution, such as United States or India, they are supposed to act as an arbitrator, and they will also have a finality with respect to understanding according to the constitution. That is, it is they who will actually say that what is the right understanding and what is the right approach. So they have finality with respect to interpretation of powers of various organs, and that places judiciary in a very interesting situation. Otherwise, generally we tend to believe that judiciary is the least powerful of all the organs because they do not have power over either sword or string, but because of this power of ultimate interpretation, they exercise extraordinary overarching impact over legal system. Now while exercising this power, they are also governed by this basic concept of separation of power doctrine, sometimes in an absolute sense, in many legal systems not in absolute sense, but of course they are supposed to be governed by some broad parameters. There lies the significance that while deciding these things, whether they are transgressing the limit set for themselves also, because so far as the limit set by constitution with respect to other organs, they will decide that whether they have transgressed the limit or not. So far as the limit set for themselves under the constitution is considered, it is they only who will decide their limitation, and that places judiciary in a very interesting scenario. So while exercising all these powers, there are various situations which can arise. Sometimes they are treated as very conservative, sometimes they are treated as more proactive. So in this sense, the term judicial activism also crops up. The term judicial activist, not activism, judicial activist was for the first time used in an article written by Arthur Schlesinger Jr. in Fortune magazine in 1947, where he used the term judicial activist, and he basically used this term for 4 judges and more importantly with respect to Justices Douglas and Justice Black. Now if you will see his article, the problem was that although he has used the term judicial activist, that these are the judges who are judicially activist, but he has not given any clear cut definition that what we mean by an activist judge in contradiction to other or in contradistinction to other concepts or a conservative judge. So far as this term appearing in judicial order is considered, so far as the recorded things are available, most of the people trace it to the order of Judge Joseph, who used this term in Theriot versus Mercer in 1959. Now, let us try to understand that what is the broad meaning which has been given by various people, scholars, judges, people who are otherwise interested in the working of judiciary, that what is the meaning they give, or what is the meaning which accrues to the term judicial activism. At the onset, we must understand that there is no perfect definition which is available, and that is why we will try to see the content with respect to which there is a broad agreement that if these are the situations which are prevailing, then we can say that it is a case of judicial activism. So, if you will see the term judicial activism as defined in Black's dictionary, they broadly say that judicial activism is that philosophy where decision making of judges are influenced by the personal views of the judges. That is, where their decision reflects their personal understanding in contradistinction to the strict understanding of law. Now, as I suggested that this term is understood from various perspectives by various people. So, if you will see Justice Verma, who in India is considered as one of the activist judges, for him that the term judicial activism is a positive term. He says that judicial activism is all about active implementation of rule of law. Now, that is an interesting part, because nobody will deny this, that judiciary must be implementing the rule of law. But what we mean by active and passive, that is a different issue. Justice Rehnquist of United States, for him, who is considered as a conservative judge, for him judicial activism tantamounts to judicial legislation, which is strict no-no. That is, you are transgressing your limit and you are acting as a legislator. That is, as if under the garb of judicial decision making, you are actually making laws. Now, why this concept become important? This concept becomes important because this understanding of judicial activism actually challenges and contradicts classical Anglo-Saxon tradition, where judges are supposed to be a neutral umpire, they are supposed to keep their mouth shut till the time they ultimately decide the case, and they will decide the case on the basis of strict interpretation of provisions of law, and not going more or lesser than what law intends them to do. So, that is why in most of the countries governed by Anglo-Saxon tradition, this issue becomes quite relevant. But again, it is not that this has not been challenged by the judges of this system. For example, Lord Denning thought that under the garb of a disciplined judge under Anglo-Saxon tradition, you cannot ask judge, or in his opinion, judges cannot afford to be a timorous souls. That is, they will have to actually decide the cases in a best possible manner. They cannot act as if that if they will do this, some wrong will happen, and that is why they just become passive. Now, the problem arises because of something which has been clarified by Justice Holmes also. That is, the issue is that the interpretation of law is not that routine manner as most of the people like it to be, because the words which has been used by the legislatures are not very are not crystal. They are not transparent and unchanged, as if that this is a meaning with respect to which everybody will agree and they will not change come what it may be, and which creates the problem even if a judge wants to be a strictly disciplined judge, because he don't have any strict guidelines to follow that this is the meaning which must be ascribed to a particular word. Under none of the circumstances any other meaning can be given to that word. So, for the proper understanding of this issue of judicial activism, we will take cases from certain representative legal system, and we have chosen to actually look into United States and Indian legal system. United States, because many people believe it is the judges of the United States Supreme Court who actually initiated all this process of judicial activism, and India because of the fact that we are supposed to understand the Indian scenario vis-a-vis the concept of judicial activism. So, let us start from the United States understanding. So, the classic case for this is always Marbury versus Madison, which is cited. Now, when we talk about Marbury versus Madison, all of us know that here the court came to this conclusion that the legislature don't have an ultimate power. The legislature and the executive, they are controlled by the constitution, and there are certain things which cannot be done even by the legislature. And this is the case which established judicial review, and by and large through the process of judicial review only these issues crop up. That is the issues of judicial activism or judicial restraint, as will come to subsequently. They are the issues which crop up. So that was the first case. Now secondly, the second important case which is often quoted is Dred Scott case, Dred Scott versus Stanford, which was decided in 1856, where the court suggested that even if a free slave is non-citizen, and they came to this understanding by controlling the powers of the legislature. They suggested that because of understanding of private property law, even a slave who is free, so far as his citizenship is considered, he still remains non-citizen, and law actually through legislative enactment, not much can be done with respect to regulating of these issues in federal territories. The most significant thing with respect to all this started happening from 1954, and the famous case was Brown versus Board of Education, where the affirmative action cases came to the court, and the court actually struck down this law where they suggested that the segregation on the basis of color, that is white and black, is unconstitutional. Now more of this will come to subsequently, because as I suggested, the affirmative action policy was looked into in Brown's case, and this has been a bone of contention vis-a-vis legislature and the judiciary for long in United States, and still perhaps remains. The second case which I have chosen after the Brown versus Board of Education is Roe versus Wade, which created lot of furor, lot of controversies, lot of agitation from both sides in United States. That was a case which was dealing with the issue of abortion, which of course is a touchy issue in United States because of conservative understanding of religion by certain sections of the Christian society, where they think that abortion is something which is irreligious, which is against the mandate of the God, and that's why they always say that law should actually prohibit abortion. Whereas in Roe versus Wade, the Supreme Court upheld the right of a woman to abort a child by saying so that is covered under the right of privacy and liberty of a woman to decide that whether she wants to give birth to a child or not. That was the interpretation of certain provisions of the Constitution with privacy, liberty, so on and so forth. But the interesting part of this was that while deciding this right, that yes, if a legislation takes away her right, that legislation will be treated as unconstitutional. They went further and suggested that in certain cases law can regulate abortion, and for deciding this they must take certain issues in consideration. They must take certain issues, keep certain issues in mind for the purposes of deciding that when it can be regulated, and they suggested that it can be regulated in cases of, say, where the health of the women is involved, or where we can say the prenatal health of child is involved. And the interesting part was that they suggested that abortion can be of course even prohibited say after second trimester, so on and so forth. Of course, with respect to the last part, in subsequent order Supreme Court modified it. But so far as our issue of judicial activism is considered, that is one thing to actually say that these are the rights which are inherent in certain constitutional provisions, and that is different to say that beyond a certain limit you can do this and under certain circumstances you can do that. That is generally considered as an absolute domain of the legislature, and there lies the criticism that to what extent judiciary, while deciding the constitutionality of a provision, can go. As we are talking about, the most significant part of this was being felt in affirmative action policy. So subsequently Baki's case came, that is Regent of California University versus Baki, where again they were supposed to look into the affirmative action policies. Now the court in affirmative action cases has come to a situation where actually they are trying to actually micromanage the affirmative action policy, and micromanaging the situations generally is not supposed to be the task of the judiciary. They are supposed to actually look into the legality, constitutionality, arbitration of a case, that is as an arbitrator, not in the sense of ADR. So in those cases, this creates a problem of judicial activism. Now let us move to the Indian position for the purposes of appreciating the same concept of judicial activism. So initially in 1950s and 60s, by and large Indian courts were conservative except for issues of right to property. And in right to property, of course, they started intervening right from the beginning because of the fact that right to property was a fundamental right. And when the Indian state tried to take away the property of landed class by abolition of Jamindaris Act in many of the states, all were challenged, and the courts were actually striking down those laws by saying, in many of the cases, not in all cases, by saying so that it goes against the fundamental right to property and violates the right to equality. And it has created a problem of conflict, a situation of conflict between parliament and the court, so much so that our first Prime Minister Pandit Jawaharlal Nehru said this in parliament, that judiciary and the lawyers, more so with respect to lawyers, he suggested that they have purloined the constitution, that is, they are not allowing constitution to work in the right spirit. The so far as the issues of personal liberty is considered, the court was conservative. So in A.K. Gopalan's case, we saw that the court suggested that if there is a law and that law is getting followed, then beyond that the court cannot do much with respect to violation and infringement of personal liberty, so far as the personal liberty is being taken away according to the procedure established by the law. After 1950, certain cases cropped up, such as Khadak Singh case and Satwan Singh case, and which ultimately culminated into Maneka Gandhi's case in 1978, where Supreme Court came to this understanding that this procedure established by law has to be understood in totality, not in isolation. That provisions of Article 21 has to be read in conjunction with Article 14, 19, not in isolation. And when we read these three articles together, which Supreme Court suggested is golden triangle, they suggested that this procedure established by law is actually as good as substantive or due process under the American legal system or the US legal system. Now that is an interesting part because of the fact that many people criticize that coming to the due process clause through this judicial interpretation process is actually creating the problem of judicial activism, because when the constitution was getting drafted and constitution was getting enacted, adopted, most of the people were actually against the due process clause, because the committee led by Sir B.N. Rao, who was the constitutional advisor to the Constituent Assembly, was informed by Justice Felix Frankfurter that due process can create problems, so it is better that you do not use the due process clause under the constitution. So it was a conscious effort and endeavor on the part of the constitution framers to not use the due process clause. They consciously used the procedure established by law clause, and even after that, through the process of judicial interpretation, the court came to the same conclusion. Now after this dramatic shift in Maneka Gandhi, court has been expanding the limits of this personal liberty, right to life under Article 21, and in Hussain Ara Khatun case, they suggested that Article 21 also includes right to speedy trial, and every person has a right to speedy trial. And through series of orders in Hussain Ara Khatun case versus state, that is Hussain Ara Khatun versus state of Bihar, Supreme Court ordered that under trials must be freed by following a certain process. So that was the first significant case. In S.P. Gupta's case, actually it was with respect to appointment of judges. Here the Supreme Court expanded the locus standi. Now what is locus standi? Locus standi is standing of an individual to seek a redressal from the court, that is, it gives a right to an individual to come to the court. In a classical sense, in an Anglo-Saxon, in a country governed by Anglo-Saxon jurisprudence, it is generally understood that only the person whose rights are aggrieved, that is a person aggrieved whose rights are violated, can come to the court of law. A third person cannot come. There, of course, there were certain exceptions when through as a guardian of a person who is not in a position, they were allowed locus standi, but classical understanding was that. There, the court actually expanded the locus standi through two modalities, which was subsequently also accepted in most of the cases and has now been deeply embedded and ingrained in the Indian legal system. That is, now the court understands locus standi as that any citizen or a representative has standing if as a citizen even a diffuse right is getting violated. So, in those cases also a citizen can come to the court of law taking an issue on behalf of all citizens, or representative where a say poor person, disadvantaged group person who is not in a position to get the judicial machinery triggered, on their behalf also they can come to the court of law. So, that is how they expanded the locus standi of an individual to come to a court of law. And this is also known as what we call as PIL jurisprudence, that is public interest litigation jurisprudence, which has been most say debated issue vis-a-vis what we call as judicial activism. So, in a public interest litigation, most of the traditional understanding of an Anglo-Saxon jurisprudence were diluted. So, locus standi was diluted. The only rider was that a person must seek the redressal from the court in good faith, that is pro bono publica, not to promote his personal interest. Now, we must give this credit also to the court of law, that when the court has come to this conclusion that people are actually violating and transgressing their limits, they have come down heavily, such as in the case of Subhas Kumar v. State of Bihar, where the petitioner was actually trying to get a personal grudge settled through public interest litigation. Court imposed the fine. Not only they refused to hear the matter further, they imposed fine also. And to that extent, court in certain cases has actually tried to regulate it. But all said and done, this controversy always remains, that whether they will entertain or not remains an absolute domain of the court, that whether they think it as a issue in pro bono publico or not. So, we can appreciate this issue by looking into certain areas of intervention by Indian courts. The most important area of intervention has been human rights. So, for example, in Sunil Batra versus Delhi administration case, court came to this conclusion that a person cannot be put in solitary confinement. Or for example, in D.K. Basu's case, Supreme Court again came to this conclusion, or rather they provided a guideline, detailed guideline, which again something which people criticize, that detailed guideline with respect to future course of action is a legislative domain. Judiciary must decide the dispute and the matter end there itself inter partes. Whereas in D.K. Basu case, the court actually suggested that what are the rights of an arrested person and in what manner arrest has to be effected. Of course, they did so by saying that if these are not getting followed, then the fundamental rights under Article 19, 21, 20, 22 are getting impinged upon. So, in a way, court was saying this, that we are not laying down this guidelines on our own. We are just laying down these guidelines for the purpose of giving effect to certain constitutional provision. And in that series, Visakha case is also there, where for long, almost till 2013, it was acting of course as a statutory law. That is the guideline provided by the Supreme Court, through which Supreme Court tried to control the sexual harassment at workplace, where they suggested that sexual harassment committee must be formed, and sexual harassment at workplace is impingement of a right of a women under Article 14, 15 and 16, more importantly right to public employment. So, in those cases certain guidelines to be followed. And interestingly, these guidelines were also supposed to be followed by a private enterprise, which are generally against whom generally the fundamental rights are not there. And as I was suggested, that almost till 2013 legislature never came up with a law on that, and it was Visakha guidelines which were actually ruling the roost and was taking care of issues in this domain. The second important area in which they have intervened is environmental protection. Now, in say Gotavarman case, there are a series of orders through which they were actually controlling the forest activity in throughout the country, so much so that timber trade, felling of trees and taking away certain things from forest, they were all governed through the Supreme Court orders. Subsequent to that, to protect the environment. They came up with what is popularly known as CNG case also, where they almost decided the fuel policy of the country. That is, it is only the CNG which can be used as a fuel in public transport. So in a way, this is considered as a domain of legislature or executive, that on what mode the public transport must be run should not be decided by the judiciary. But again, they suggested that if that is not being done, the right to healthy environment under Article 21 is getting violated. If right to healthy environment under Article 21 is getting violated, the right to life under Article 21 is getting violated, and if right to life is getting violated, the court cannot just sit and allow that to happen. Now, in environmental cases also, in 1987, again it is MC Mehta versus Union of India, also known as oleum gas case, where the court actually came up with an order which created a new jurisprudence. That was one of the interesting thing. But the other things which were actually done, that they suggested in what manner environmental dispute must be heard, they actually gave an indication that environmental court must be established, so on and so forth. And let us understand that there are certain other cases also where they have done something which are criticized as cases of judicial activism, such as TMA Pai's case, where while upholding the right to education as a fundamental right, and while talking about right of minority educational institute to establish educational institute, and also the private private players to come up with educational institute or universities, they suggested that since education is not a profiteering business in India, and that's why the fee structure, once it allows profit making by the private players, that is unconstitutional. So far so good, but they went further and suggested that we are going to constitute a committee to actually look into the fee structure which has to be followed, and in what manner admission process has to be regulated. So in a manner, they actually came up with a detailed list with respect to the manner in which the education institutions must be taking care of their admission process. Now, let us come to the second part, that is the issue of judicial restraint. What we mean by judicial restraint? Judicial restraint is other side of the coin of judicial activism. The judicial restraint issue actually means that there are certain things, issues, which cannot be decided on the basis of judicially manageable standards, that is, which the judges can effectively look into and regulate. And if an issue arises which cannot be managed by judicially manageable standards, in those areas court must recuse, courts must step back, and they must not go further, because that will lead to a situation where not much can be done by the court of law. Secondly, when we talk about judicial restraint, the idea of judicial restraint is that certain issues are to be left to the other organs of the state, that must not be decided by the court of law. So issues of, say, public policy. So public policy must not be decided by the court, that what is good public policy, what is a bad public policy. But please understand that here we are not talking about a public policy which is unconstitutional or illegal. If a public policy is unconstitutional or illegal, their court has all the right to look into and come up with further orders, even they have the power to strike it down. But if they are the issues of merely being a good or bad policy, then generally court must restrain itself. And the people say that in those areas, the judges must understand that their idea of public good must not affect their decision. If their idea of public good is affecting their decision, then it is a case of judicial activism, and judicial restraint demands that they must not be entering into that territory. And yes, the people make political choices, and political choices can sometimes lead to a bad policy, sometimes it can lead to a good policy. And in a democratic society, people must bear the consequences of their political choices. It is not for the court to actually intervene in cases of political choices. This is also important to understand that judicial restraint is very important for the court, because unlike other organs, the orders of the courts are final. So you cannot go to somebody. So if legislature does something wrong, you can come to the court. If executive does something wrong, you can come to the legislature, or legislature can make them answerable, and you can again come to the court. But if the court does something wrong, if it is a lower court, you can come in appeal, and if it is Supreme Court, you are not left with anything. Of course, with this understanding that in limited cases, review petition and curative petitions are there, and that's why the courts of law must be little bit more cautious in deciding the issue this way or that way. And secondly, unlike the other organ, the courts are also supposed to decide their jurisdictional limits also, and that's why because of these kinds of extraordinary power, the courts must exercise restraint, because they must remain humble because of realization of all this extraordinary power. Now let us see certain recent cases to understand this. One of the judges, Justice Roberts, who is generally considered as a conservative judge, they are more in the favor of judicial restraint. Recently in 2012, a case came to the Supreme Court that is by the name of National Federation of Independent Businesses versus Sebelins, which is also known as Barack Obama's healthcare case. There the court suggested that yes, beyond a certain limit, that taxation power by invocation of Commerce Clause is bad. You cannot interpret it in such a liberal manner that it violates the private enterprise's right to conduct their business in a particular manner. But yes, while deciding this, they by and large also recognize that within their sphere, the courts can actually, pardon me, not courts, actually the legislature and the executive can decide to do certain things. So this is something which is recognized by US courts also, that yes, there are certain areas where courts can intervene, but while intervening they must exercise their restraint. Same happened in India in 2007 when Justice Kadzu came up with an order in Divisional Manager Aravali Golf Course versus Chandarhas case, where it was with respect to the appointment of a person who was accommodated in the post of gardener, because the post of gardener was only available in golf course, but they claimed that since they were working as drivers, so they must be regularized as a driver, which the High Court allowed. Supreme Court struck down this order by saying so that creation of post is an executive and legislative domain. Their judiciary cannot intervene. So whether posts must be created, whether they must be abolished, by and large that is an executive or legislature domain. And court, while deciding this, came up with series of statements where they suggested that the court must exercise restraint and they must not transgress the limits set by the constitution, because as is the case with the other organs, same is the case with the judiciary, that judiciary is also bound by the constitutional norms. So after looking into all this, in conclusion or in summary, we can say that there has been a great amount of vacillation in judicial pronouncement and understanding with respect to judicial activism and judicial restraint. Sometimes they say that we must be conservative, on other occasions they say that no, we must be little bit more proactive. Of course, they may not say so in clear-cut terms, but they act like that. So by and large, we can say that the approach of the court has been contextual, and when we try to generalize something which is contextual, it creates a problem, because in other circumstances it will highlight certain weaknesses which the court must not have looked into. And at the same time, there is a very thin line between judicial activism and judicial restraint, and the judges must remind themselves that they are also holding a constitutional position, they are also governed by the written constitution, at least in India and United States and in all those countries where they have written constitution, and they are also supposed to honor the constitution, because while deciding the limit, when they try to uphold the constitution as an part and parcel of their oath of being a judge, similarly while exercising judicial power also they must uphold the constitution. Thank you very much.